My office has represented a number of clients who were involved in accidents in New York State, but they either live in another state or in another country. And at first blush, they think they don't have a basis for a lawsuit, or they can't bring a lawsuit because they don't live in New York. But that's not the case. If you're injured in New York, and if a New York party or someone who's responsible for what happened to you resides or does business in New York, you have access to the courts in New York and can proceed with a claim. Sometimes it's expensive to come back and forth to New York, and while it's best for me to have face-to-face meetings with my clients, we can do a lot of this today thanks to Skype, with the internet, email, all types of things that make it much easier than it used to be. The only time the client would need to come back to New York would be for the deposition in the lawsuit and for what's called an independent medical examination. And defendants are usually good about trying to schedule those close in time for an out-of-state or out-of-country person so that they only have to come back once for that. Then they will come back for trial if the case goes to trial. The only other reason typically that I would ask a client to come back during this time period is if the doctors that my client is treating with in another state, it's going to be too hard for them to come to New York to testify if necessary at trial. Or if I need medical expert information with respect to a motion that may come up. In that case, I'll ask the client to come back to New York to be examined by a board-certified physician in the area of specialty that my client's injuries are, and then we will rely upon that expert in conjunction with the records and testing done elsewhere if necessary for motions or for trial.